Welcome. This is video 7 of the Assessing Risk of Significant Harm training course for child protection practitioners. Videos 5, 6 and 7 explore the legal concept of significant harm. They present the three components of harm, significance and likelihood, and how these are incorporated into Risk 2 and other tools. In videos 5 and 6, we introduced the building blocks of risk assessment. In video 5, we started by asking what is harm, and in video 6, what makes harm significant. In video 7, we look at likelihood. So what is likelihood of significant harm? What is important to remember when assessing risk of significant harm is that we aren't just assessing the current circumstances or evidence. We are also considering whether harm is likely to become significant in the future. If we look at the legal basis of a local authority's duty to investigate in Section 47 of the Children Act, we see the word likely at its centre. It states, where a local authority has reasonable cause to suspect that a child in their area is suffering or likely to suffer significant harm, then the local authority shall make inquiries to safeguard and promote the child's welfare. And then, when the court is considering making a supervision or a care order, the threshold in Section 31(2) states that the court can make an order if they are satisfied that the child is suffering significant harm or is likely to suffer significant harm. So likely or likelihood is at the centre of our risk assessments. We can think of the duties in the law as relating to two very different sets of circumstances. Firstly, a child is suffering significant harm. This fits on one side of the continuum. Something has actually happened or continues to happen. You have the advantage of having some evidence available to prove, on the balance of probability, that a child appears to have suffered significant harm, and you will have reasonable cause to investigate and, if substantiated, to take actions. On the other side of the continuum, a child likely to suffer significant harm in the future is predictive. You have no evidence that something has actually happened, but you fear that it will. You are seeking some basis for making a judgment that something may actually happen, and when it does, that it will cause a level of harm which will be significant to the child. So when we are looking at likelihood and prediction, there are a number of other things to consider. For example, what does research tell us about probability in cases similar to these? Is there research that tells us when it is more likely that there will be a recurrence of harm? Are there certain types of parental problems that make it more probable, or certain types of harm? And secondly, if we are concerned about the behaviour of parents and they need to make changes to reduce likelihood of future harm, how do we know they will be able to do so in the child's time frame? We'll explore these in this video. But before we look at other considerations, we need to check what the law authorises us to do, and in particular, how case law interprets this. As with other legal components we have considered, we turn to case law to help us understand how courts interpret the words likely and likelihood. This ensures that we practice in the spirit of the law and how this is interpreted. The law underpins our practice, and of course the test of how the law has been used is proven in courts. However, most cases where the law is followed does not reach the courts or its scrutiny. It is therefore important to remain vigilant in day-to-day practice to ensure people's rights are always protected. In child protection practice, case law makes the law much more practical, making it much clearer about how we should be acting lawfully. So, what does case law tell us? It tells us that likelihood means a real possibility that it will occur. But a conclusion to that effect must be based on a fact or facts based on a balance of probabilities. Likelihood is predictive. It does not have the advantage of evidence of actual behaviour, but rather an assessment of likely behaviour or the effects of such behaviour in the future. If you imagine low levels of harm that is not currently significant, but left unchecked and unmodified in the longer term may become significant in the future. Examples could include low-level neglect or emotional harm becoming significant over time. In video 6, some of the indicators of substantial harm was abuse or neglect that was a series of events over a long duration and frequent. So, a real possibility that it will occur based on facts and evidence established on a balance of probabilities. Case law also reminds us that there is a difference between what is feared compared with what is established as fact. This is similar to the earlier point that likely harm does not have the same advantage of evidence. But also think about the word fear. When we are fearful, it is emotional and subjective. There is a fear of getting it wrong, and getting it wrong and the child is abused is worse than getting it wrong and the family's rights to privacy are abused. Fear will influence your decisions. So, something established as fact is more likely to be based on objective decision-making. Something feared will be more subjective. This is something to be kept in mind as you make decisions. And because your judgment is predictive, it is always an uncertain basis for making decisions. Case law also suggests the importance of establishing how likely in the context of how severe. Case law tells us the more serious the harm is, the less likely it has to be. And in contrast, the less serious the harm, the more likely it has to be. In practical terms, very serious harm, such as serious injury or sexual abuse, that is assessed as being unlikely to take place, may still pass the threshold of significant harm because the consequences are so severe if they do become real. And low level of harm, which is persistent, we can think of lower level neglect or emotional harm, which is ongoing and assessed to be very likely to take place, may again meet the threshold of significant harm. This is how the case law was written. The reason for adopting a comparatively low threshold of likelihood is clear. Some harm is so catastrophic that even a relatively small degree of likelihood should be sufficient to justify the state in intervening to protect the child before it happens, for example from death or serious injury or sexual abuse. But it is clear that Lord Nichols did not contemplate that a relatively small degree of likelihood would be sufficient in all cases. The corollary of the more serious the harm, the less likely it has to be, is that the less serious the harm, the more likely it has to be. So, if there isn't much likelihood of harm, the predicted seriousness has to be severe to justify intervention. Practically keep these in mind. If it isn't likely to happen, the harm needs to be severe to justify intervention. If we think about likelihood in the spirit of the way we refer to balance of probability, we may imagine that likelihood meant more likely than not. However, case law has corrected this. It is clear that likelihood should not be interpreted as more likely than not, but rather that the potential of it happening was a real possibility, and that possibility couldn't sensibly be ignored. The statement reads, "The first on which all 5 of their lordships were agreed was that the words, 'is likely to suffer significant harm,' did not mean that such harm had to be more likely than not to happen in the future. It was enough if its happening was a real possibility. A possibility that cannot sensibly be ignored, having regard to the nature and gravity of the feared harm in the particular case." So, case law helps us practically. Ask yourself, is there a real possibility it will happen? Is it something you can't ignore? Are the consequences of what you fear may happen so great you couldn't ignore it? Why does this need to be done now? Why can it not wait? The courts have asked this in particular in relation to predicted emotional harm. Emotional harm can take a long time to materialize, and some children in very adverse environments do not show these effects. So why now? Why not wait a little to see if the real possibility it will happen becomes more obvious? We've looked at how the law, and case law in particular, helps us clarify likelihood. What does research offer us as predictive indicators? A Department of Health paper in 2014 looked at parental capacity to change and some of the factors that seem to be linked to a higher likelihood of future harm. These included the types of abuse, with cases of neglect and previous abuse more likely to result in future harm, and that children with developmental delay and special needs are more vulnerable to this happening again, and very young children who require rapid parental change are very vulnerable. Parental mental health also features strongly in research as a predictive factor. Likelihood is higher where there are certain types of personality disorder, combined mental illness and learning disability, paranoid psychosis, and any significant parental mental health problems. And then when we consider those predictive factors related to family and social circumstances, research indicates that there is a higher likelihood where there is parental conflict and violence, situations of high stress, and lone parents where there are no family or social support networks. The third element that helps us understand likelihood is our understanding about change. It is important if we are concerned about the behaviour of parents and they need to make changes to reduce likelihood of future harm. How do we know that they will be able to do this in the child's time frame? The change cycle, or stages of change model, presents us with a sequential change process. It starts at the stage of contemplation or thinking about the change required. Then we have preparing for change, taking action, and then maintaining the change. Before we need to even start to really think about change, there is a pre-contemplation stage. What research tells us is that if people are in fact at pre-contemplation stage and haven't yet thought about change, the likelihood of successful change is very poor. How do we ensure that people are at contemplation rather than pre-contemplation. The 7 steps of contemplation is a checklist of the key conditions that have to be met to confirm people are ready to think about change. Some of those conditions include that people accept there is a problem, have some discomfort about the problem, see themselves as part of the solution. If these are not yet met, it suggests people are at pre-contemplation and further work is required to get them ready for change. In motivational interviewing, the phrase change talk is used. This indicates that the more you talk about change, how things will be when things have changed, what people intend to do, the more likely it is that people will do these things. Other tools, such as the continuum of motivation, can be used. This clarifies whether motivation tends to be internal or external. Internal motivation to change is associated with higher likelihood of success. Statements such as, "I want to change," and "I don't like things as they are more promising than, "I agree to do this so that the family can be reconstituted," or "I'll do whatever you say." You can use this tool to clarify whether the family is externally or internally motivated to change. If it is primarily external, it indicates that further work needs to take place with the family on their perception and sense of responsibility so that the prospects of sustained change increases. Then we look at some of the other stages in the change model or stages of change. We hear about lapses and relapses. Lapse is a slip, temporarily going back to previous behaviour, but lapse is temporary. It is short-term, and steps can be taken to learn from this and recover. Lapses provide useful information about how well people's new coping strategies are and what needs to be reinforced. A relapse is a more fundamental deterioration back to previous behaviour. It tends to be more permanent and less amenable to correction. And in the area of child protection, where there is a lapse, the question of likelihood of significant harm has to be addressed, and safeguards may need to be put in place whilst recovery is addressed. In some research about change, other factors were identified that indicate a higher likelihood for successful change. These included where the family had a positive attitude towards professionals trying to help them, where parents were taking responsibility for their behaviour, where the difficulties were well balanced with the strengths of the family, and where the level of abuse hasn't been high. Another aspect to consider when looking at change is to remind ourselves about the child's time frame. Can the change necessary be completed within a child's time frame? That is, the time frame where it is worthwhile for a child to wait, but not so long that the cumulative harm caused to the child is greater than the damage of removing them into the care of others. In other words, they've waited too long for things to get better. As an example, imagine parents who both use substances and require rehabilitation and treatment over several years to be able to care for their children. The question is, do you wait, or do you need to make more permanent arrangements for the child? It is difficult as you do not know the results, you only predict. And if we are optimistic and hopeful for parents, we can hold on too long in the hope parents can make substantial changes. Years later, with hindsight, we regret not having been more decisive earlier. Ask yourself, Are you optimistic? If so, how reliable is that feeling? It is easy to get focused on parents and parental problems. The focus for child protection practitioners is the child at the centre of this and having their needs met. Lastly, very young children have greater prospects of rehabilitation and recovery than older children. This has resulted in the policy focus on the adoption of young children, whereas teenagers are less likely to make full recovery if they have remained abused as they got older. The likelihood of young people being able to recover from the effects of abuse deteriorates generally with time. So, a 14-year-old is less likely to recover than a 10-year-old child. Exercise 4. What is likelihood? Exercise 4 builds on your understanding of likelihood. In this exercise, we'll touch lightly on the 3 areas that help us with likelihood. Firstly, how case law defines it. Secondly, what research tells us. And finally, what we know about capacity to change. Imagining the implications of these 3 areas on your case example will help you relate this information to your own practice. From the Downloads page on the Practice Resource module, you'll find a workbook to accompany this course. This exercise is in the workbook with instructions and an example of a short recording template for you to complete. You can pause the video in order to fill in your workbook. Based on your own case example, write a brief statement, 2 sentences, to explain the evidence available to you to prove there is a real possibility that they will be harmed, or otherwise, there is no real possibility that they will be harmed. Based on your own case example, write a brief statement, 2 sentences, to explain the evidence available to you to prove this is something you can't ignore given the severity of its harm, or it is something you can ignore and why. Reflect on the statement, the more serious the harm, the less likely it has to be, and the less serious the harm, the more likely it has to be. Consider the matrix in your workbook. Based on your own case example, decide which box of the matrix to locate your case. Write a brief statement, 2 sentences, to explain what evidence you had for your decision. Research provided indicators of higher likelihood of harm. Please look at the indicators in your workbook and, based on your case example, tick any relevant indicators. Reflect on the exercise. Has this indicated anything about your own case? If so, what? In your workbook, there is a 7 steps of contemplation checklist and a continuum of motivation checklist. Based on your case example, please complete at least one of these and provide observations. You can, of course, complete both exercises if you wish. Reflect on the exercises you have completed. Are you able to identify factors that increase likelihood? We looked at case law, research, and parental change. Which of these did you find most interesting? Please record your observations in your workbook. There are additional resources available that expand on these 3 areas. These are available from the Practice Resources section. You have completed the 3 videos that look at significant harm. These are: what is harm, what is significant harm, and likelihood. Once you have worked through video 7 of the Assessing Risk of Significant Harm course, please progress to the next part, which is video 8. Video 8 summarizes the introduction section and introduces some of the other specialist assessment tools that can be used to support your risk assessment.